Section 3. The legal aspect of money laundering. This session focuses on the many international and national institutions that are responsible for monitoring the money laundering system. This will also cover laws and regulations for ML, as well as who is responsible for anti-money laundering. International Organization and Regulation. Financial Action Task Force. The Financial Action Task Force, or FATF, is an intergovernmental body whose purpose is the development and promotion of national and international policies to combat money laundering and terrorist financing. Its 40 recommendations are backed by mutual evaluations of its member countries. Countries which are not members of FATF may be members of an FATF-style regional body. In 1990, the FATF issued recommendations to combat the misuse of financial systems to launder drug money. The recommendations included international cooperation, including extradition of subjects, implementing relevant international conventions on money laundering, criminalizing money laundering and enabling authorities to confiscate the proceeds of money laundering, implement customer due diligence, record keeping, and suspicious transaction reporting requirements for financial institutions and designated non-financial businesses and professions. Establish a financial intelligence unit to receive suspicious transaction reports. These recommendations have become the benchmark against which a country's rules are assessed. The 5th EU Money Laundering Directive. The 5th EU Money Laundering Directive, or 5MLD, has come into effect, replacing the 4th Directive. As the directive predated the UK plans to leave the EU, the UK government has transposed the directive into UK law. Members must continue to meet the requirements of the money laundering, terror financing and transfer of funds, information on the payer, regulations, as well as the additional requirements of the 2019 amendments, the main changes being that relevant persons must take reasonable measures to understand the ownership and control structure of their customers. If the beneficial owner of a body corporate cannot be identified, reasonable measures must be taken to verify the identity of senior managing officials. Check that all persons with significant control have been filed on the Companies House Register and report any discrepancies that are identified. Confirm that electronic verification is a reliable source, provides sufficient assurance, and is free from fraud. Additionally, the definition of tax advisor has been extended to those offering indirect tax advice. The USA Patriot Act of 2001. The USA Patriot Act of 2001 amends the Bank Secrecy Act by requiring all financial institutions to establish anti-money laundering programs. The Act is intended to strengthen the USA's measures to prevent, detect, and prosecute money laundering and the financing of terrorism. The USA requires suspicious activity reports, or SARs, to be filed anytime there's a large or suspicious transaction to the Financial Crimes Enforcement Network, or FinCEN. FinCEN serves as the USA's Financial Intelligence Unit, or FIU. The USA's financial institutions are also required to follow strict customer identification programs in order to verify the true identity of each customer and deter money laundering. Wolfsburg Anti-Money Laundering Principles. On the 30th of October 2000, a new initiative to combat money laundering was unveiled. What differentiates this initiative from many of the existing initiatives is that it has been put forward by the private sector. 13 banks signed a set of principles known as the Wolfsburg Anti-Money Laundering Principles, or the Wolfsburg Principles. The Wolfsburg Principles are a non-binding set of best practice guidelines governing the establishment and maintenance of relationships between private bankers and clients. Asia-Pacific Group on Money Laundering. Established in 1997, the Asia-Pacific Group on Money Laundering is an intergovernmental organization consisting of 41 member jurisdictions focused on ensuring that its members effectively implement the international standards against money laundering, terrorist financing, and proliferation financing related to weapons of mass destruction. Individual accountability for anti-money laundering. Every good citizen has the responsibility to prevent, avoid, and inform any activities regarding money laundering. However, there are some specific organisations, such as banks, financial institutions, and roles such as senior management, that require more focus towards money laundering. Case study. From 2003 to 2008, Thomas Hayder served as the Chief Compliance Officer for MoneyGram, a money service business specialising in money transfers. As part of his responsibilities, Mr. Hayder was responsible for ensuring that MoneyGram had an effective AML-CFT program that requires timely reporting of suspicious transactions. He was also in charge of MoneyGram's fraud department. During that time, there were thousands of complaints placed by customers who reported that they were victims of lottery or prepayment fraud and instructed to remit money to fraudsters via MoneyGram agents in the US and Canada. Although receiving a wealth of information from complainants, Mr. Hayder and MoneyGram's fraud department did not conduct an investigation of the complaints or the outlets from where the complaints were generated. An investigation would have allowed Mr. Hayder to suspend or terminate any agent participating in the illegal activity. According to a December 2014 FinCEN assessment of civil penalty, Mr. Hayder failed to implement an appropriate AML program, conduct effective audits, or terminate known high-risk agents. As a result of FinCEN's investigation, Mr. Hayder was removed from his employment at MoneyGram in 2008 and was individually assessed for a $1 million civil money penalty in 2014. FinCEN also sought to ban Mr. Hayder from working in the financial services industry. Exceptions to the Professional Code of Ethics. Professional accountants, lawyers, bankers, and auditors are required to maintain the confidentiality of their clients' activities. This is required by the Code of Ethics and is therefore mandatory. However, if they discover that their clients' or customers' activities are related to money laundering, they should notify these to the appropriate authority. It is their legal duty. Failure to do so may impose fines, imprisonment, or both.